Good afternoon, lawyers. My name is David Carr. I am a solo practitioner in San Diego, California. And for the last 30 years, I've focused my practice on legal ethics. I'm going to speak on client trust accounting for a few minutes and tell you about some essential points that are encompassed in new Rule Professional Conduct 1.15. As I'm sure you're aware, we have new rules of professional conduct that went into effect November 1st, 2018. And the client trust accounting rule is now new Rule 1.15. In some aspects, it's very similar to the prior rule, Rule 4-100. And if you have a client trust account, you're probably familiar with that rule. There are some differences, though, some important new developments that you need to know about. And I'm going to talk about those and also a reminder about some important points that pertain to client trust accounts before the new rule and after the new rule. New Rule 1.15 has several significant changes. The most significant new change in Rule 1.15 is that the rule now applies to advanced unearned fees. Prior Rule 4-100 applied to advanced costs, but the prior rule did not apply to advanced unearned fees. That is, a sum of money paid by the client as security to the lawyer to cover fees that had not yet been earned by performing legal work. Some lawyers are surprised to learn that under the prior rule, there was no obligation to put those funds of that character into a client trust account because the ABA Model Rule 1.15, which many lawyers studied in law school, indeed requires that those unearned advanced fees, those advances, be placed in a client trust account. That was not the rule in California until November 1st, 2018. New Rule 1.15a requires that all funds held for the benefit of the client, as well as funds held for the benefit of persons other than the client, must be placed into a client trust account. And that includes unearned advanced fees. The second new development in 1.15 has to do with the treatment of flat fees. Flat fees have become very common in legal practice in the last few years, and in some aspects we've been encouraged to consider flat fee representation because there are certain advantages to flat fees. That the client knows how much money they're going to spend, and one advantage that lawyers always saw in flat fee representation was the idea that a flat fee was earned on receipt and therefore could be deposited into an operating account and spent immediately before, in fact, the fee had been earned. New Rule 1.15b makes it clear that a flat fee is an unearned advanced fee. And like every other unearned advanced fee, in the normal course, must be placed into a client trust account. But 1.15b also furnishes a safe harbor provision that allows an attorney to take a flat fee and put that money into an operating account and presumably expend those funds immediately, provided that the client is given notice and an opportunity to waive their right to have the flat fee placed into a client trust account. So the import of New Rule 1.15 is that a lot of attorneys who took unearned advanced fees and had been putting them into their operating account are now going to have to put that money into a trust account, maintain those funds in trust unless it's a flat fee and unless the client has signed the necessary waiver requirement to take the money and place it in a flat fee and place it in the operating account. That's a pretty significant change from the prior rule. Another significant change to Rule 1.15 is that it now explicitly covers not only funds held for the benefit of clients, but also funds held for the benefit of persons other than the client. Attorneys, of course, are fiduciaries to their client, and the rule requiring segregation of funds and holding them in trust traditionally has stemmed from the lawyer's fiduciary duty to the client. However, the new Rule 1.15 now makes it clear that other persons other than the client, may have a right, an interest in funds pursuant to a contract, such as a medical lien, a medical provider, or pursuant to a statute. And again, there are medical providers who, by statute, have a lien against settlements that would require that the attorney protect those funds, keep them in trust until in the interest of the non-client holder is perfected. So new Rule 1.15 explicitly incorporates provisions that have been found in case law and includes the duty to protect funds held pursuant to statute or contract, non-client funds, and medical providers. Medical liens are the clearest example. Finally, one thing that has not changed are the requirements, very strict requirements, that an attorney keep complete records of all funds coming into the possession of the lawyer, client funds, and funds held for the benefit of other people. There are 4 kinds of records that are required, and those are spelled out in the new rule: a general journal for all transactions in the trust account, a specific client ledger for funds held for the benefit of clients, bank statements, and a monthly reconciliation. And it's a good idea to create a paper trail, create a paper reconciliation, which shows that you have reconciled the bank statements against your own records. If you hold client funds and you maintain a client trust account, it is essential that you obtain a copy of the State Bar's Client Trust Accounting Handbook, which is available on the State Bar website, calbar.ca.gov. That is literally the Bible as far as the kind of records you need to keep, and offers extensive guidance on the format of those records. Thank you very much. It's been a pleasure speaking with you, and happy lawyering.